Whoop, I was called Judiciary Committee to order, and please join me initially with a Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We're missing all the Dems. Up there we are.
Okay. Come on in. Oh, hello. Oh, that's all right. No
You
problem.
only missed the pledge, no, nothing else. I was just about to go look for you guys.
All right. Hi.
Sorry,
No,
the
no,
clock in the room we were
no problem.
showed we were on something.
Hi. How are you?
Good, how you doing?
Good, good, good. All right, I'm going to open the public hearing on Senate Bill 185 and recognize Senator Prentice, the prime sponsor. Senator, welcome.
Good morning, Chair Lynn and members of House Judiciary. For the record, again, my name is Sue Prentice. I'm the state senator from District 5, representing 15 communities, large part of Grafton County, Sullivan County, and one in Merrimack County, the beautiful town of New London. So it's great to be here today. Thank you for taking the time to talk with me about Senate Bill 185. So I'm introducing this to establish a study committee to look at the various barriers to discharge of patients, really to safe environments, including, from acute care facilities. And these environments could be home environments, they could be continuing care environments, and we'll get into that a little bit further, and that's why you have the purpose of a study committee before you. So this started well over a year ago, and in conversations with the New Hampshire Hospital Association, I became aware that there's a growing population of inpatients in hospital beds and acute care hospital beds that don't need to be in those beds, but are in them because they don't have any safe place to be discharged to. And so I'd heard that this was a statewide issue, and I talked to the hospitals within my district, which there are 3 of them, and confirmed that indeed they have patients who are in beds that other patients need and could occupy, but they don't have a place for them to go for various reasons. Hence, again, the study committee. Every case is different. This issue is most impactful on the adult that's actually waiting to either go to a safe home location or to another facility. That isolated world that they are in that acute care bed starts to close in on them, and they actually, I've heard numerous stories of dwindling or declining because of the atmosphere that they're in. And the closest folks that they come to at that point are actually staff, become like family members celebrating birthdays and holidays. There are patients that have been in these acute care beds for upwards of 100+ days or more. And I gather from some folks that are here to testify behind me, you'll hear some of those exact statistics from their acute care hospital. So in 2022, the New Hampshire Hospital Association did publish a report on barriers to discharge. This report highlights patients across the state that remain in these acute care hospital beds when they no longer need acute inpatient care. The patients remain in the hospital, again, not because they don't have a need to leave, they need to stay there, but because there's a barrier to discharge. They range from lack of available supports in the community, including within their home, to insufficient long-term care beds, to legal barriers that may exist. So there's not one particular solution, and every case has been different that we've talked about. In other words, these are, again, not medically necessary that they occupy these beds, but they remain there because there's sadly no place for them to go. So in the early days of this, and this was a bill that was retained and we came back to work on it again this year, we gathered stakeholders from hospitals to from hospitals to disability rights to AARP to adult protective services. We brought in people from all different walks that take care of, or their purpose. They have some crossover into this area of adult care, and we couldn't come to a consensus because there were different situations, and each situation required a potentially different solution, and some of them may be legal in nature. So with that, I was fortunate enough that Senator Carson stepped forward and tried to assist me with this and said, why don't we move ourselves into a study committee mode and really drill down on, considering that we have a report that gives us what the barriers are, but looking at each of those, what are the real solutions that we can bring forward, we can all agree on, and that we can enact. So most importantly, those patients or those individuals who are sitting in those hospital beds that don't need to be there have a place that they can go. Their life is not a hospital room. They can emerge back into the community in a setting that fits them. That's most important. The second piece, backing that up, is acute care hospital beds can be few or far between, and we need to make those free when we can, so that patients are not waiting in emergency departments for beds or being transferred to other facilities. And oh, by the way, there might not be an ambulance available for that interfacility transfer because our healthcare system is facing all of these different challenges. So with that said, I'll wrap up. Again, I'm thankful for the opportunity to talk to you about this. We have a good idea of what the barriers are. We can't agree on a solution. Senator Carson was wonderful in collaborating with me on building a study committee so we could really drill down and get these stakeholders to a place where we can have solutions for these individuals who will no longer need to be, living at One Medical Center Drive, potentially in Lebanon or whatever an address might be, but back in their community. Thank you, Chair Lynn and members of the committee. I'd be happy to take any questions you might have, and if I don't have an answer, and I do have another bill I have to go introduce. We have representatives here from the Hospital Association and St. Joseph's Hospital and maybe more. Thank you.
Thank you for taking my question. I was a nurse for 42 years, most of that in intensive care. I understand exactly what you mean. But having personally run into a thing, safety is a huge issue.
Yeah.
I tell people, use the safety word. They're not safe coming home, But my husband was in the hospital, and I tried to get him into an acute care. Medicare was my obstacle. Did you find in any of your research that Medicare ended up being an obstacle? We ended up paying for ourselves out of pocket for him to go to acute care. But then I fought the insurance company and won after 2 years. But Medicare was a problem with this. And then the other thing that I found in working for years was families don't want them to leave the hospital, because once they leave the hospital, somebody's going to be responsible for that bill. But until they leave the hospital, the bill is ongoing and nobody's responsible. That's not the right word, but nobody's paying the bill right then and there. So those were two different things that I wondered that when you form this committee, hopefully that you will look at, because it's not just no place to go. There are other entities that seem to get in the way.
So Representative Perez, thank you for your question. And financial barriers are indeed part of the discussion. I actually heard more about the Medicaid component of this than the Medicare component of this. So I will leave that to some of the experts that I have, that we're fortunate enough to have with us. But certainly that's part of it. And if you can't, if I may, if you don't have, say, family members or legal guardians or someone who's responsible for paperwork. I don't think legal guardian is the appropriate term for me to use here. And we can't get them engaged to even enroll them in one of these programs. That's a barrier as well. I mean, it is like literally being on an island for so many of these folks. So services in the community, financial barriers, they're all intertwined in this. Thank you.
Thank you.
Good morning. It's wonderful to have you here. You should stay. Um, I don't think anyone will question the need to resolve a serious problem. My question to you is, what makes you think that 6 legislators are going to be able to solve this problem if all of the work with those who are directly involved has not resulted in a solution?
Thank you for the question, Representative Smith, and it is good to see you this morning. There's been time that's lapsed since we first engaged stakeholders and tried to develop solutions. And with that time, we've gained some more advocates and interest, not just in the legislature, but within the communities. But at a certain point, I had to put this on, we basically held it to the side. And after it started to sit over here, those, including, again, hospitals and advocates who were not in the initial discussions, started to come forward. Senators as well as representatives started to be contacted by their local hospitals or within their districts, whatever area they're covering, and they were asked, like, why aren't we moving forward with this? How can we help you? So in response to your question, it is my sincere hope now that we have put a light on this and elevated the issue, that we can get better commitments at the table to solve the problem, or folks will continue to sit where they are. You're welcome. Thank you.
Other questions? Yes,
Yeah, thanks, and thanks, Senator, for taking the question. I guess my one concern, and maybe it's a practical thing, I'm guessing it's a practical thing, is the end date for this of November 1st, 2024. It seems like a lot to accomplish in a very short period of time. I don't know if that's because we're in our second year of our cycle, and that's sort of a practical limitation, but I was wondering about whether or not that would provide enough time to actually achieve what this sort of intends to tackle, which is very large.
Thank you, Representative Turner, for your question. It is very large, and it is half of this is the fact that we are in the second year. But I actually think we need to leave the date, and we need to, and I know it sounds aggressive, but the accelerated timeline is where I think, now that we have the light on the issue, we have people that are really willing to engage in this. By keeping this timeline in place, there's nothing better in my experience than a deadline that has to be met.
Senator Ford.
Also, as a practical matter, doesn't having this committee's report will come after or during the filing window in the two bodies. So this allows the sponsors of this bill, first of all, encourage them to be a bipartisan group, but doesn't it also give them just a few extra weeks to work it up before the next legislature convenes in January 2025? Yeah.
So thank you, Representative Horgan. So your question that our window would be small between the time that this
No, my question is it kind of gives you a little bit more time before the filing deadline, so they don't have a bill that's introduced by this study committee has a looser filing deadline than one that was introduced by one or more legislators acting on their own. Is that right?
Yes. Okay.
Other questions? Representative Reese.
Thank you, Mr. Chair, and thank you, Senator, for presenting this to us this morning. In your previous research or study that you've done, were the county nursing home representatives from the county nursing homes a part of the discussion? And if not, perhaps going forward, the county nursing homes may present at least a temporary solution, at least getting them in on the dialogue. Has that been the case in the past?
Thank you, Representative Greason. And through the Bureau of Elderly and Adult Services, as well as AARP, there were some connections made to county nursing homes because they definitely have a stake in this. So they have been, and we would obviously encourage them to be involved. I think what I know is one of my experiences has been with study committees is it does give you the flexibility, even though it's built of legislators, you can decide, basically draw consensus on who you want to talk to. and make sure that they are in the room for, whatever points in time, as well as the entire the entire time the committee meets. So yes, on the counties, welcome them back. We'll continue to start with this core group and make sure that's appropriately expanded for involvement. Thank you.
Thank you, Mr. Chair. Thank you for taking my question, Senator. Do we have numbers of how serious this problem is in stacked up patients in the state of New Hampshire?
Good to see you, Representative Stapleton. I miss Claremont. So the Hospital Association will be able to give you the best number, but there was a point where one of the towers at Dartmouth Hitchcock had 150 patients that needed, this was within the last 2 years, that needed placement and had nowhere to go.
Well, thank you.
Thank you, Mr. Chair. Thank you for taking my question. I'm going to show my ignorance on healthcare because you're using a term that I don't recognize.
They're waiting for it. Okay, good.
I don't know what an acute care
You need to tell me.
facility is.
Oh, a hospital. So, a hospital. So you have 26 acute care facilities in this state. Hospitals are considered acute care, and some of them are also designated as critical access hospitals. So I'm talking about Parkland Medical Center. I'm talking about Dartmouth Hitchcock or Dartmouth Health. I'm talking about the Elliott Hospital.
All right, which now it makes sense that, follow up?
And
Now it makes sense that Representative Greason asked about the county nursing homes because they're obviously not acute care facilities.
no, they're typically skilled nursing beds, and this may be, depending on the nature, a place for that particular individual to go.
All right, thank you very much.
You're welcome.
Thank you, Mr. Chair, and thank you, Senator, for taking my question. My question is, okay, we have the New Hampshire Hospital Association, AARP, and all these other groups. Why haven't they formed a core group and come up with a solution over the years?
So, Representative, thank you for the question, and I am going to have to leave, but what I am going to say, they're waiting for me in HHS. What I am going to tell you is that we got those folks to the table, and we could not come early on to a consensus because the problem was not as well understood as it is now. So they were all there, but we couldn't come to a consensus. Time has lapsed. Interest has built. Acute hospitals have spoken up. Advocates for families and patients have spoken up. So we're just in a different place now. Thank you. And I do hate to cut it short, but they are waiting for me, if that's okay.
Thank you very much,
And I
Senator.
have really
Appreciate it.
enjoyed the back and forth.
All
Thank you.
right, thank you. All right, next, I'm going to call on Representative Hankin Phillips, please.
Good morning.
Morning, welcome.
Representative Hacken Phillips from Grafton 12, which is the towns of Hanover and Lyme. And Senator Prentice is the actual expert on the topic. But I did want to come today as a co-sponsor and express my support for the bill as amended by the Senate for three particular reasons. One, I think this is a life and death issue. We should all recognize that every bed that is not turned over on a timely basis in a tertiary care system means that someone who has potentially a life-threatening issue cannot be addressed at that hospital. They cannot receive the care that they need in the moment. And they're pushed further outside the envelope of the service area of our state into other service areas to address their needs. And that, 5-10 minutes difference can be a huge life and death matter. So I just really want to reiterate the urgency of the issue. Second is that this is really a business viability issue for our state tertiary hospital systems who are already meeting several challenges post-COVID recovery. And while each one of these opportunities to turn a bed over is another viability point in their business model to remain, in operation, it's such a critical issue for our state. So please do not underestimate the economic value of this study committee. And then third is just to say that, this is a public health issue and that for every, Granite State community that can support a proper tertiary care system, our communities thrive and are healthier. So of course, this really does matter. So please keep the big picture in mind as you make your deliberations today. And that's it. So I'm happy to take any questions.
Questions for this witness? Seeing none, Representative Tripp.
Thank you, Chair. Thank you for taking my question. Once again, I have to show my ignorance of the healthcare system because you used the term tertiary healthcare. What exactly does that mean?
So thank you for the question. I'll try to do my best layman's definition for you. And basically, a tertiary care system is a large hospital system that has multiple levels of care. So not just, kind of like walk-in emergency services, but also like proper surgical and internal medicine, and I mean the whole gambit of multiple healthcare points of service and like topics of medicine are all practiced under one roof, more or less. Does that help?
Well, you explained follow up. Sure. You explained a lot of things, but you never used the term tertiary in your explanation.
Oh, it's a large hospital system.
It's a large hospital.
Yeah. So, for instance, Dartmouth Health is considered a tertiary hospital system because they offer a wide breadth of services, not just, internal med, but it could also be surgical, or it could be neurological, or it covers many different areas of medical practice.
One more.
Sure.
So a secondary healthcare facility would be something that like a local healthcare.
Well, I don't want to oversimplify the matter, but I think earlier there was a mention about the county nursing home system where that would not qualify as a tertiary care system because, for instance, they don't have an emergency department and they don't operate surgical cases there. So it's kind of a step down, like nursing primarily driven operation. So it's a different level of care. It's a little lower, I would say. So I'm hoping that helps for the description.
Other questions for this witness? Seeing none, thank you very much.
Thanks.
Next, I'm going to call on Ben Bradley from the Hospital Association, please.
Thank you, Mr. Chairman and members of the committee. For the record, my name is Ben Bradley. I'm the Vice President of State Government Relations for the New Hampshire Hospital Association. Our hospitals are dealing with unprecedented challenges regarding the inability to safely discharge patients once they're no longer in need of acute care services. The issue is complex, and the reasons vary greatly. As noted by Senator Prentice, last year 185 was retained in the Senate and amended this year to establish a study committee that will look into the various barriers to discharge for patients medically cleared but unable to leave the acute care hospital bed. Of all the bills in the legislature this session, SB 185 is one of the Hospital Association's top priorities. I cannot stress that enough. On any given day in hospitals across New Hampshire, there are dozens of patients, and I can suggest that it's well over 100 patients today in an inpatient bed, medically cleared for discharge, but unable to leave the hospital. These lengthy, non-medically necessary hospital stays are caused by a number of barriers to discharge, including but not limited to things like Medicaid eligibility determinations, securing guardianship, access to long-term care and other specialty settings, something as simple as transportation, and occasionally insurance denials. These barriers impact not only patients unable to leave the hospital, but also patients whose care may be delayed due to a lack of an inpatient bed availability. Understanding why patients remain in an acute care hospital bed longer than medically necessary will help identify areas where improvements can be made to reduce the number of patients affected. That's why this bill is so important. We are eager to work with members of the study committee, along with a large stakeholder group that this will require, to support any efforts to engage the community, brainstorm legislative and non-legislative solutions, and advocate for patients facing these challenging circumstances. I want to thank you for the opportunity to provide comments. Please take this bill seriously, and we ask for your support. I know you will take it seriously. I'm happy to answer any questions you have. We do have a updated report on barriers to discharge coming out very soon that I would like to provide the committee. This will identify the areas in our hospitals where barriers exist, how much of a barrier that is, how many unnecessary days patients are staying in hospitals, and other factors as well. Representative Smith, you, if I may, you had asked about what we think a committee like this would do. What makes us think that a committee of 6 members of the legislature could help resolve this issue? I think it's leadership at a state level to identify those legislative solutions and non-legislative solutions that we can move forward in the next biennium, potentially with budget proposals and other policy considerations. Thank you.
Representative Smith and then Representative Testerman.
Thank you. Actually, this is a question for you, Mr. Chair. Why is this bill before this committee rather than, for example, Health and Human Services?
Well, that's an excellent question for which I don't have, the only answer I can give is it came in our mailbox, and I did not think to raise an issue about it. But you raise a good point. I think it's probably too late now for us to.
It is too late. Once the hearing has been scheduled, it cannot be, changed to another committee. But I think that the questions that at least one of our colleagues asked reflects that very precisely that this is not an area where we have built up expertise. And so I don't think we are the right place for this. And I add to that my continued concern that I still don't see why, when the principals have not been able to reach an agreement, since it's so clearly in their own self-interest to reach an agreement, why you think 6 people in the end of a term, meaning that there is not going to be any legislation coming forth from this, why you think that would solve the problem? I need to be enlightened. Thank
So just in response, I think that initially this bill, when it was proposed in the Senate, went to Judiciary because it focused on patient abandonment and the need for guardianship. This has changed to some extent to create this study committee. Those elements remain because there are patients who are stuck in hospitals that have been abandoned by their family and need to be assigned guardianship. So there are areas where we as a hospital association, our members feel the legislature needs to become familiar with and help to support legislative solutions in future years. That's why we feel it's necessary to engage a study committee on this issue.
Right. Representative Testerman. You need a microphone.
I don't see a reason for this study committee. I see a lot of members, interested people who could sit down and solve this, and we seem to be asked to come in to fulfill some need that I don't see being presented. I don't understand why a study committee is necessary, why the interested people and parties who are going to be part of that can't sit down across the table and sort this out, and then finally come to us and say, I need this action. It just seems useless.
Respectively, Mr. Chairman, if I may respond.
Of course.
I think it is critical to have legislative engagement on this issue. We need legislative solutions, and this committee will help to foster those legislative solutions, or at least be able to report on their findings for legislative solutions in future that can be referenced in future legislatures. I'm going to just give a couple of examples. One is it's very challenging to secure a guardian when patients are left in a hospital and need to secure a guardian because either their family is incapable of making determinations for their care, safe care, or nobody is available. We need a strong process for securing guardianship. That will include ensuring there are enough guardians in New Hampshire, which may include increasing the number of slots that the state allocates for guardianship under their contracts. It may include expedited guardianship, as we saw during COVID-19 when the circuit court designated a specific judge for these determinations so patients could secure a guardian and decisions could be made for those patients to move into an appropriate facility. Another is around Medicaid eligibility. Currently, the process for securing Medicaid is very cumbersome. It's an extensive process, and if there's a way that we can move legislative proposals that help to ensure patients may be able to move into a new facility, into a more appropriate facility before actually securing Medicaid eligibility, then we want to pursue those options as well. But these are all topics that we feel are justified bringing to a legislative committee that needs to become familiar and provide some reports by gathering stakeholders for legislative solutions and non-legislative solutions in the future, because we don't want to try to propose a legislative solution when it can be resolved without legislation. So respectfully, I can't share how strongly enough we believe this is an important bill for the legislature.
All right. Representative Testerman.
I guess it just seems to me, you know the answers. And you come to us with a bill to say, do this, rather than talk about doing it, just a bill for each of those 2 or 3 that you came up with, and I'm sure you have more. And because we're getting towards the end of a term that many people who are going to be on some committee won't be here. So it just seems to me that you're basically asking a committee to do it, just piddle around with it and then drop it. And it worries me. If this is so critical, let's do it. Come up with 4 or 5.
So I didn't hear a question there.
Well, the question really is, why are we doing a study committee when you already know the answers, or at least the potential answers? Put the answers forward.
Thanks for the question, Representative Testerman. I'm going to just refer to my previous answers.
All right. Other questions? Yes, Representative DiLorenzo, and then Representative Turr, and then Representative Stapleton.
Okay, mine's just a quick one. Thank you for taking my question, and thank you, Mr. Chair. When do you expect the report to be issued?
I would hope before the sunset of this committee in November.
No, that's not a good answer. Do you have a report on data now?
We have data that we're gathering from our hospitals now, yes.
Okay.
Representative Turr.
Because I just want to.
Oh, I'm sorry.
Follow up?
Yep, of
I
course.
just feel like we would have a better idea of what we're dealing with if we saw the numbers in the situations.
And
Thank you.
if I may, Mr. Chairman, that's exactly the point that we're trying to make, which is we're gathering information. We want to provide that to a legislative study committee and work with the state and the legislature to move some of these things forward. So thank you.
Representative Turr.
Yeah, actually, thanks, and thanks for taking the question. That was actually a good segue to my question, which is, and this is from my non-legislative head on at the moment, but do you have the ability to sort of identify these days and situations in the administrative data, either in the hospital discharge data set or the all-payer, claims data set, so that it's possible to sort of, and I'm thinking within the time frame of a committee like this, examine sort of the subsets within the bigger problem that it sounds like maybe this report already is focused on, like within different payer groups, within different facility types and things like that, so that it's not just kind of an aggregate. I guess the real question is the data available, and is that something that could be dealt with by a committee?
Thank you for the question, Representative. Yes, there's been a lot of labor and intensive work on gathering data from our hospitals on the challenges that they're facing with getting patients to an appropriate level of care. I feel very confident that we will be a valuable resource to the efforts of this study committee, and I believe that we can hit the ground running on day one without simply doing introductions and a overview of the committee. Even the first meeting that we have, I think we can get to some really strong and comprehensive information that will help inform the committee very quickly.
Representative Stapleton.
Thank you, Mr. Chair, and thank you for taking my question. Having been familiar with helping constituents through the Medicaid application process and also involved with the complexities of guardianship, I can appreciate how much delay could be attributed to those two factors alone. Never thought about the hospital emergency room stack up in such a regard, but because they're so backlogged in DHHS, Medicaid, and the courts handling guardianship cases, there's a great deal of time and resources that are absent to address that. If you could condense those, it probably would make sense that you could move these people along a lot quicker. I recognize that the legislation is a component of all the tools that you need, and so it's an important piece that brings it into focus to the head of the culture. Question, could you give me a rough percentage about how many people are stacked up on guardianship and Medicaid issues in the system within New Hampshire?
From a inpatient acute care hospital bed setting, our report should identify that, meaning should identify how many patients are awaiting a determination from Medicaid for Medicaid eligibility before they can secure it and move to an appropriate level of care. We will be able to identify that. Similarly, guardians, we know what patients are in need of a guardian, and identifying and securing those guardians is part of the effort to get patients to where they need to go. So yes, I feel confident we can answer those questions.
Yes.
Can you just give me a rough ballpark kind of an idea, other than medical, transportation, other factors, how much guardianship, Medicaid might represent in very rough percentage figures of all those people stacked up in our system?
So I'd say there's over 100 patients statewide and on daily, and on any given day for each of those categories, I would say there are dozens of patients.
Right.
That's my best.
Representative Andrews.
Thank you, Mr. Chair, and thank you for taking my question. Has anybody in the hospital association or any other, like AARP or anybody, been to individual legislators and said, we need this bill or we need this bill?
I think that's no, but it's part of a comprehensive effort to propose as part of this study committee.
Representative Smith.
I'm a little unsure about how to proceed, but the witness who is ably presenting to us the position of the Hospital Association tells us we need data, tells us the way to proceed is to have this study committee, and tells us the information that we will need for the study committee, which expires in November, will be available to us by November. So I think that there's a little disconnect here, and I hope you don't mind my making that point, Mr. Chair, and I'm making that comment to you, not to the speaker.
Right, no, I hear you.
May I respond? I don't know if I was unclear in responding to Representative DiLorenzo. Our data is available within the next, we have historical data. We have a former report on this. It was issued in September. We're updating that report. That should be out this month, which should give insight to the study committee that would be established this summer and work diligently to identify important legislative and non-legislative solutions for next legislative session for the next legislature to consider as part of their report. We have the data. It's not coming out in November. It's available now, and I'm happy to provide what we have historically gathered and any updates that may be forthcoming. But it's misguided to believe that we don't have data available now, and we'd have to wait until November to get that to the study committee. I apologize if I was misguiding.
Representative Manos.
Thank you, Mr. Chair, and thank you for taking my question. I have two questions. One is, I represent Stratum, so I'm wondering if you could review the definition of an acute care hospital, because I'm thinking through whether Exeter Hospital would fall under
Yes.
that. They don't have a psychiatric unit, they're a general hospital, so I was
Yes.
wondering about that.
Yes, acute care settings are hospitals. All hospitals in New Hampshire are acute care settings.
Yep, go ahead.
My second question is, when someone's occupying, excuse me, when someone's occupying a bed for non-medically necessary reasons, who's paying the bill for that? Who's absorbing the costs of that?
Thank you for the question, Representative. The hospital does not get reimbursed for any services provided that aren't acute in the hospital. So that patient, there's no payment to the hospital, and the hospital absorbs those costs.
Other questions for this witness? Thank you very much, sir. All right, Christine Caldwell, please.
Good morning, Chairman Lynn and honorable committee members. This is my first time doing this, so I'm a little nervous. So just want to let you guys know. My name is Christina Cardwell, and I'm the Director of Care Coordination at St. Joseph Hospital, and I thank you for the opportunity to testify in strong support of SB 185. We are very appreciative of the collaborative efforts of Senator Prentice and Senator Carson in addressing a critical issue faced not only by hospitals, but most importantly, our patients. Hospitals have been tasked with caring for individuals who have been abandoned in the emergency room or main entrance of a hospital by families who either cannot care for them at home or are unwilling to do so. Hospitals are also finding that patients are admitted for a medical condition, treated, and at discharge, the family is either unwilling or unable to care for the patient at home, leaving the long-term care planning of that patient now up to the hospital. This results in an extended length of stay for what we call social barriers. Currently at St. Joseph Hospital alone, there are 5 patients in this situation. 1 was brought in through the emergency room and abandoned by family. 3 of the patients have family who are unable to care for them at the patients at home.
You know, Ms. Caldwell, I don't mean to interrupt you, but you've given us your written testimony, and I'm not, so I guess what I'm saying is we can, all of us can and will read this, but there is some, we have some time pressure because we're running a little late. So if I don't want to interrupt you, but in terms of productivity, it's not particularly productive to just read what you've already given
Sure.
us.
So I'll just mention the numbers because I think the numbers are important.
Sure.
So currently at St. Joe's, there are 5 patients today who have been abandoned. The total number of days in the hospital for these 5 patients is 756 days. Of those 756 days, only 66 days were medically appropriate. So that's 690 days that a bed was held up for patients who were waiting for guardianship, Medicaid, and then placement into another facility. That at St. Joseph's, our average length of stay is 4.1 days. So if you do the calculations for that, with those 5 patients taking up 690 days of bed days, that left 168 medically appropriate patients from our community that then could not be admitted to those beds in that time frame. So that I had it all planned just to read the whole thing. So.
I understand
But
that.
I think that out of everything that I wrote here, I think that's the most important piece.
And I assure you, we will, the members of the committee will read your written testimony. Don't worry about that. But so thank you. Questions for this witness, Representative Andrews.
Thank you, Mr. Chair, and thank you for taking my question. How long has this acute problem been going on?
It's been going on for, I would say it's been getting worse over the years. I've been a nurse for 18 years, and I would say maybe in the last 5, we've started to see the uptake of abandonment, or at least in my experience. It's been in the last 5 years that I've seen it. More so since the pandemic, the COVID pandemic. It definitely ticked up from there. So it's been going on for a couple of years.
Other
But getting
questions?
worse.
Other questions for this witness? Representative Andrews?
Thank you, Mr. Chair. Okay, this has been an ongoing problem. Has the hospital done anything to try to correct it, or has just gone on and now it's getting to be a severe problem?
So hospitals have tried to figure out creative ways to discharge patients safely. My background is the care coordination, and it is our responsibility to get a safe discharge plan for patients. And there's been times when we have a safe discharge plan for home, but then the family refuses to take that patient home. So we have a safe discharge plan, but the family says no. We can't really control what the family does. Hospitals do, or at least our hospital, I would say, has a contract with a Genesis facility that we can occasionally use if there's a long-term care bed available, where we will pay the facility to take the patient while they're waiting for their Medicaid application to go through. But the issue is finding the bed and getting them to agree to that contract. So we've tried to do things. I feel that now at this point we need assistance from legislation. You're welcome.
Other questions for this witness? Yes.
Beyond the health of the individual who is in the system in one of your beds, what is the cost to all other healthcare payers into the system with the burden of this occurring?
I don't really understand the question.
So
I'm
is
sorry.
there a cost to all healthcare users for providing care for these individuals who are not paying?
I would say no. There's not a financial cost to other healthcare payers for this particular patient sitting in a bed. There is a cost to the hospital. That's a loss of, at minimum, $1,660 a day that the hospital's not getting paid.
But presumably, I think what the legislator was getting at is presumably the hospital attempts to recover that in some way in charges to other patients. I mean, the rates go up, so to speak.
I'm not sure if that is actually the case.
Okay.
I don't have anything to do with the billing process in the hospital.
All right, Representative Horgan.
Yes, I experienced a situation with a family member who unfortunately was admitted to the ICU of a, well, I guess I now know it's called a tertiary care hospital, a major hospital here in New Hampshire. And they, what we ended up doing was admitting them to hospice, and they actually stayed within the same building, but they were being cared for by a different organization, with different funding and so forth. So is this something that is this one of the strategies that this committee would be looking into possibly? It's sort of the opposite. It's kind of the flip side of the other problem. So there's actual bed and a space available in the facility, but they still handed the patient off to a different organization that's doing a different type of care than what the hospital was doing. So I don't know if I've made myself clear, but is that one of the things that this committee would probably be looking at?
I don't necessarily think that they would be looking at that. Medicare does have a hospice benefit for what we call general inpatient. So hospitals have contracts with hospice agencies for those patients who are at end of life and need to be in a facility where the Medicare hospice benefit pays for the patient to be in the hospital, and that agency then comes in to help care for them.
Okay, good. Thanks. I sort of understood what happened to us. Obviously, I had other things on my mind aside from the Medicare benefit, but thanks. So So that's something that's already being done effectively. So the committee probably wouldn't have that much trouble with that particular issue. So thanks.
Correct.
Representative Blunt.
I just wanted to make a statement, that's all. It's just saying, I'm really surprised that you're able to get patients into a nursing home because Medicaid usually always makes sure that the Medicaid has gone through before a patient is admitted to a nursing home. So the critical it must be very, very critical in order to, as I say, have this going on.
Other questions? Seeing none, thank you very much.
Thank you.
Is there anyone else who wishes to testify on Senate Bill 185? All right, seeing none, I'm going to close the hearing on Senate Bill 185. And I'm going to open the hearing on Senate Bill 507, and I will recognize the prime sponsor, Senator Whitley. Senator, welcome.
Thank you, Mr. Chair. Good, what are we here? Morning, members of the committee. For the record, my name is Becky Whitley. I'm honored to serve New Hampshire Senate District 15, which includes the wonderful communities of Bow, Concord, Pennacook, and Hopkinton. It's good to see many of you. Today, I'm honored to introduce Senate Bill 507, a bill to ensure justice prevails in the Granite State. This bill deals with the post-conviction process, and it extends the time to petition a court for a new trial in certain cases. As a refresher for folks not familiar with the post-conviction process, the post-conviction process is in place to protect both innocent and guilty individuals from inherent human error in the criminal justice system. Unfortunately, there are still innocent people who are convicted of crimes and spend years in prison while the real offender remains free. Although it's exceedingly difficult to overcome a conviction, even for an innocent individual, convictions are being overturned and individuals are being exonerated with increasing frequency. In post-conviction cases, an exoneration may occur when a person who's been convicted of a crime is officially cleared based on new evidence of innocence. This can occur through a pardon based on actual innocence, an acquittal at retrial, or a conviction being vacated and indictment dismissed. The use of DNA testing has been used to include or eliminate suspects and exonerate those convicted in serious crimes. There have only been 3 exonerations in New Hampshire. This low number is despite the fact that DNA testing has been available since the 1980s. Although we wish this was because New Hampshire has a justice system that is perfect, data suggests that the more likely reason for the low number is that wrongful convictions just aren't being discovered. One bar to discovery of wrongful convictions is New Hampshire's existing archaic statute, which provides only 3 years to overturn a conviction. This timeline does not allow for consideration of changes in forensic science, new investigative leads, new scientific techniques or procedures, or other newly discovered or better understood evidence. We all know that science is constantly changing, and the courts in New Hampshire must be able to accommodate this growth. I want to point out that New Hampshire is out of step with the rest of New England and is wildly out of step with the rest of New England and is only one of 6 states with absolute timelines, which we can talk about further. I also want to point out the American Bar Association, their standard on post-conviction statute of limitations states that, I quote, a specific time period as a statute of limitations to bar post-conviction review of criminal convictions is unsound. And that's what New Hampshire has. Conviction finality is meaningless where the conviction is wrongful. There can be little comfort to victims in convicting the wrong person. I want to provide an example to illustrate why this bill is so necessary. A man named Gary was convicted of a brutal assault and murder out of Massachusetts in 1983. His innocence was not litigated until 2017, 35 years later, well after the statute would have run. Gary's exoneration began with the discovery that bite mark science was not what forensic odontologists had believed it to be at the time of trial. Because the Massachusetts statute accommodates changes in science and its statutes of limitation, Gary's case was able to be litigated and Gary was exonerated. this would not have happened in New Hampshire under our current statute. I just want to note that the Senate Judiciary Committee spent a great deal of time working with the parties in crafting this language. You'll see that it is slightly narrowed from the original version of the bill. There are many, many folks at the table that have worked on this bill, and I will say they continue to work on it. As the version that you have before you was sort of hashed out in a room with county attorneys, the Attorney General's office, the Innocence Project, folks who actually work in the field. But of course, as we continue to think about the issue, we want to get it right. So I would say, and the folks behind me can describe it in greater detail, I think folks are on the same page that we do need to change this absolute timeline, but we need to get the language just right. So, I am an attorney, but I do not practice, nor have I ever practiced in this area. But there are many very, very talented lawyers behind me who do practice in this area. So I will defer technical questions to how this post-conviction process works to them. Thank you very much, and I appreciate the committee's consideration of the bill, and I'm happy to take the questions that I can.
Questions for this witness? Representative Wallace.
Thank you, Mr. Chairman. Thanks for taking my question. In the case you cited in Massachusetts, what was the actual perpetrator caught and prosecuted, or was just the wrongfully convicted individual?
I don't know that. Thank you for that question, but the folks behind me will know that. Yeah.
Thank you.
Thank you for that question.
Other questions for this witness? Thank you very much. Representative Mee.
I have to
Thank you.
lean around the corner
I know,
to see you, Representative.
Yeah. Good to see you, Senator.
You too.
Just a quick one on new scientific understanding. Is that defined anywhere, or does it just get its common definition?
Yeah, and that's a very good question, and I think that is the sort of one of the areas of conversation. It is likely, just like in other states, that and your chair knows this well, that oftentimes a statute is written and the courts need to interpret it, and we want to strike that balance in statute by being clear enough but not being overly prescriptive. So thank you for identifying that issue.
Other questions for this witness? Seeing none, thank you very much.
Thank you very much.
Next, I'm going to call on Cynthia Musso, please.
Good morning. I'm Cynthia Musso. I am a staff attorney in New Hampshire.
Thank you.
Good?
Good.
Okay. I'm Cynthia Musso. I'm a staff attorney with the New England Innocence Project. I have been with the New England Innocence Project since 2019, but before that, I was a public defender in New Hampshire, and I was a law clerk. I actually was in Hill South, Judge Lynn, when you were there as well. So I'm sort of in this unique experience of having been in the pretrial and the post-conviction world, and I'm the only attorney in the entire state that's working full-time on post-conviction litigation, and the only person that's working on these innocence cases full-time. And I say all this only to say that I'm sort of in this unique position of having this understanding about how this statute of limitations is impacting our ability to litigate these wrongful conviction cases in New Hampshire, and how these changes that we're proposing today would not only help free innocent people, but would also really improve the criminal legal system as a whole. So the current version of the statute of limitations requires motions to be filed within 3 years of the rendition of judgment. This is virtually impossible to meet in wrongful conviction cases. In 2016, the National Registry for Exonerations reported that the average exoneration actually takes 11 years, which is almost 3 times that 3-year limit that's currently being set. Wrongful conviction work is very slow for lots of reasons. It's hard to find case documents in the years after things are closed and resolved. Witnesses die, they move on, and scientific understanding, which we will talk a little bit about, has changed. As an example, I've been litigating a case in New Hampshire since I started in 2019. This case is from 1988. This was brought to the court's attention in 2022, and the Attorney General's office just in 2024 found new evidence in the case, and it's been with the Attorney General's office for 2 years. It's not a fault issue. They did find the box, but it took 2 years to find it. And we're in this space where we can't find the evidence for 2 years. A 3-year statute of limitations is unduly burdensome and is preventing viable claims from moving forward. The current statute also doesn't account for changes in science. So as Senator Whitley explained, there's been this discovery in terms of bite mark evidence, and that's Gary's case, and I will speak specifically to the facts of Gary's case. But also there's been other science and scientific understandings that have changed. So arson science, pattern matching, so all the handwriting, fingerprinting, all of these kinds of things have changed over time, and we can't account for that with this statute. So if arson science at one point in time, we have a case named Victor Rosario. The man was charged with arson. They alleged that he had used a Molotov cocktail to start a fire in a building. As it turns out, fire science has now revealed that the fire was not set purposefully and was actually set accidentally. It was a wiring defect in the building. Meanwhile, Victor Rosario sat in prison for 25 years for a crime he didn't commit. If we had been in this space with this statute of limitations in this state, Victor's case would never have come to light because we still would have been in the position where we couldn't address that because of this statute. A lot of new other things have come into play, and you know, we're aware of that: hair comparisons, blood stain pattern, all of those sorts of things. And it's not just this discredited science, but it's these advances in sciences. You know, we've talked about DNA, and there is a separate statute in the state for DNA exonerations, but DNA can be useful in different ways, and that 3-year limitation can still inhibit us there as well. Not only is it true that only 6 states have absolute time bars, but 32 have no time limits for these new trial motions. And what we're trying to do is really, as Senator Whitley highlighted, bring New Hampshire in line with the rest of the country. I want to address a couple of points. And I know one of the things that we've been talking about with the county attorneys and the attorney generals is the concern that this amendment will be like a change to the standard and how the court will consider what can be grounds for a new trial. What I would tell the committee is that that standard is laid out in RSA 526(1). We are not changing, amending, adjusting, trying to adjust that standard. It's spelled out when a new trial can be granted, and that standard is the standard and will be the standard, and we're not trying to change that. This bill is only meant to request a change in when we can petition. So we're just trying to ask the court. Right now, we can't even ask the court to consider things. We're just trying to ask the court to look at it. Whether it will be granted or not, that standard remains the same. So that's one specific issue. I know that the county attorneys have raised that, you know, the language would be usable in that way. I think the language as is forecloses that because it's very specific that this is regarding the time limit and doesn't change anything about the standard, and the standard is spelled out in 526(1) with no amendments. With respect to Mr. Sifazari, who's Gary, that Senator Whitley mentioned, the reality of that case was that the original suspect in that case was a man named Michael. The police had written him off because he had told them that he didn't do it. It turns out that it was his DNA that was found on her and on the stuff at the scene. He had already died, so he was not prosecuted. However, while he was out, he committed additional rapes and murders in the community. And so that was something that could have been addressed if we had known. In terms of the new scientific understanding, Representative Ming, that you had asked about, that language is used in other states. It's used in regards to a different statute. So in Massachusetts, that language is used in terms of granting new motions, like the substance of new motions. So it has been interpreted, but not in the context of the changing the statute of limitations. But we add that because there's a difference between these discredited sciences and a new scientific understanding of an old science. So we know that DNA has changed so much over the years. Even in 2002, we were using what's called RFLP testing. We don't use that anymore hardly at all. We now use PCR testing, for example. But if I came into court and said, I want to argue DNA testing, you would say we had DNA testing in, 2003. And I would say to you, we have much more exacting DNA testing that can collect, that can detect, that can be used with more partial profiles, with less information than we could back in the day. So it has been defined in other places, not in New Hampshire, hasn't been used here, but the way it's been used in other places is different than the way we're using it in New Hampshire. The scientific understanding would still be governed by Daubert, which is the court's test in terms of determining whether new science and new scientific theories and techniques would be acceptable in the courtroom. That would still apply. So the court would still be able to evaluate that. We're not in any way trying to introduce something that would be upsetting to that case law or in any way subvert it or get around it. I'm happy to take any other questions.
Other questions for this witness? Yes, Representative Manos.
Thank you. Thank you for taking my question. As I read the bill, it would apply to both civil and criminal cases. Is that correct?
That's true. So actually, this is one of the things that we've been having a lot of discussions about. Is this statute was originally drafted to apply only to civil cases, and it's been interpreted through case law to apply to criminal cases because there is no separate statute of for a new trial for criminal cases, so it's been interpreted to apply to both. So that's correct. However, the language that we've specifically written in here is that the motion for new trial and any criminal conviction. So the bill itself, the law itself does apply to civil cases, but the amendment that we're making only applies in criminal cases. So I draw your attention to section 2 where it says this time limit shall not apply to a motion for new trial and any criminal conviction. So it actually doesn't apply to these civil cases, although the law as a whole does apply in civil cases, but our amendment does not.
Other questions for this witness? So I guess I have one. Is this 3-year limitation really of particular significance given that you have habeas corpus available?
So the thing about habeas corpus is that as you're very well aware, Judge, that would return your case only to the court where the body is held. So Concord or Berlin for the most part for us, for folks that are incarcerated. The court of conviction, which is where a new trial would be heard, is really the proper court for these cases to be heard in, because this is the court that, originally held the case and has all the evidence and has heard the case in the first instance. So the hope is that court would be able to correct their own errors in that instance. I think the other issue is that habeas corpus has sort of different standards than the motion for new trial. We've always had these sort of separate there's sort of 3 main ways to get back into court in New Hampshire following a conviction. There's a habeas corpus provision. There's the motion for new trial, which is spelled out in 526. And then there's the DNA statute, which is specific to DNA and allows you to get in on new DNA testing if you can get that from the court. I think this is a separate and important statute because it is a different standard than the Habe standard, and it puts it back in the court where it was first heard.
Okay. All right. Other questions? Representative Manos.
I just wanted to follow up. What was the rationale, excuse me, for limiting this to criminal convictions?
I mean, our concern because we're the New England Innocence Project is really solely based around criminal convictions that are wrongfully occurred. I really couldn't speak to, as all lawyers will tell you, we really know just our little field and the things that you go outside. I couldn't tell you. So from our perspective, the main concern is criminal convictions. We don't have the same perspective and we don't bring the same knowledge to the civil field.
All right. Other questions? Representative Alexander.
Thank you, Mr. Chair. Thank you for taking my question. If this bill were to pass, could you see almost everybody in the Department of Corrections filing a petition for newly discovered evidence?
Yeah.
I mean, I see this as indeterminable increase, but I see this as really big increase. Like everybody could file a petition and try to get the courts to get them to overturn their case. This seems like a mess.
So again, we're not changing the standard. So the standard for granting a new trial remains the same. That's RSA 526-1. That standard is still in place. So in terms of the court screening out these cases, they still would be able to do that through RSA 526-1. We're allowing additional people to apply for to ask the court to hear their cases. The practical reality is, having been a public defender for a very long time, although there is sort of a common idea that everybody in prison is innocent, that is actually not the case. And they actually don't say that very often. Most of our cases resolved by plea. And the practical reality is that folks that will be in those positions to ask for new trials, those motions would be immediately identifiable as uncredible, and the court could screen them out. There is no guaranteed right for counsel. There is no additional, there would be no additional costs incurred. And the reality is that I don't think people would take advantage of this. I think that's one of these alarm bells that people ring anytime we try to give people additional rights. But the practical reality is that we're keeping out valid and legitimate and important claims of actual innocence in the event if we were to say this is too big of a floodgate, is that we're closing these doors to very valid and very problematic innocence claims in order to not inconvenience the court.
Other questions? Representative
Real
Kurtau-
quick,
yes.
I'm just thinking just the staff time of having somebody in the court screen out all of these cases. That in itself, I think, I haven't spoken to inmates recently, but I think that any one of them will want to at least file a petition to overturn their conviction.
They still have the ability to do that within that 3-year time period. So if they were going to do that on that basis, they can always file that within that 3-year time period as it stands now. So if it was the case that they were intending to file that, there should have been some sort of flood-in litigation in those initial first 3 years, and there just isn't. So the practical reality is that's just not borne out by the way the numbers work at this point in time anyway.
Representative Kurtau.
Thank you, Mr. Chairman, and thank you for taking my question. I guess I'd like to know how many are currently within that 3-year time period actually filing something, because I do share a similar concern, and it's not clear in this bill if these petitions would just be reviewed by the court or if everybody would be granted potentially a hearing before a judge. And I could see this as a way, respectfully, for an inmate to say, well, I'd like to go on a field trip to the court. I mean, and I do mean that respectfully, but when you're incarcerated and you can't get out, I could see somebody being like, it would be nice to get out for a day and go to the court. I can actually get some fresh air and go somewhere for a day, see some other people. And I do mean that respectfully, but I think when you're incarcerated for a long period of time, especially the people that potentially are in there with life in prison and don't routinely get to leave. So how many, do you have numbers about how many who do file within 3 years in the
So
state of New Hampshire?
I don't work for the court, so I don't have those numbers, and I couldn't tell you. What I can tell you is, having been in contact regularly with folks that are incarcerated, most folks don't want to leave the prison and come down to the jail, which is where they would have to be if they were going to be held somewhere else. And that's really not something that they're interested in doing. It's actually very difficult to leave and come back because of the trauma of incarceration and then being re-exposed to a community beyond that. To return back into the prison after that is actually extremely traumatizing, and most people don't want to do that.
Other questions for this witness? Representative Tur.
Thanks, and thanks for taking the question. I guess looking at the language of this, it's basically hinges on newly discovered evidence and new testing and scientific understanding. Is it your sense that these petitions could be filed iteratively in the future? In other words, this is not sort of a single opportunity to file for a new case, but new scientific methods are coming out every day. I'm wondering whether or not this could lead to Representative Alexander's case, a lot of retrying and repetitioning.
I think in the event that a new scientific understanding arises that shows that you are innocent, you should be able to come back into court and make that argument. So every time new scientific understanding of a piece of evidence comes to court and says, this is evidence that we should not have taken into the courtroom in the first instance. And this is not evidence that we should be relying on because this is not reliable, this is not accurate, and this is not scientific. The court should be willing to adjust its own practices to allow those cases to come back to court. So to the extent that a new scientific understanding is going to generate additional petitions down the line, I hope that that's exactly what happens, because that's how the statute is supposed to function. If the concern is that there are going to be frivolous petitions, the reality is that, as I said, the standard remains the same, and the court can still say this is a frivolous petition based on nothing. This only allows us to ask the court to hear the petition. That was the case for the 3-year statute of limitations to begin with. So we don't think there would be additional frivolous petitions filed under this amendment. And if there was going to be frivolous petitions filed, they would have been filed in those 3 years anyway. And to the extent that additional petitions are going to be filed because there's new science or new understanding of evidence that was presented in a case, they should be.
Of course. Yep.
So just one follow-up question. I'm wondering, it sounds like essentially, there's no real standard for what would constitute new or different. So you could sort of come back almost immediately, and claim that there's an additional modification to. I'm wondering whether or not something like a time limit in terms of how soon after one is turned down you could come back again would be something that you would think would be useful.
I mean, I don't, because I think that the reality is when we think about DNA testing in 2003, which was 20 years ago, and we think about it now, it's completely different, and the science is completely different. So the practical reality is saying, oh, well, you had the ability to do RFLP testing and you didn't take advantage of that, and now I don't want you to be able to do anything with that for a while, I think is like inhibitory and allows people to continue to sit in prison for something they didn't do. So our main concern is that we don't want people to sit in prison for any longer than they need to be sitting in prison. Our concern in this case is freeing people that are innocent. So the practical reality is we've put nothing in here about adjusting for errors of law or what we call legal innocence. So the legal innocence claims would be things like they had a warrant, but the warrant didn't have the proper basis, so they shouldn't have been able to get in my house. That's not the same issues that we're addressing by this amendment. We're addressing factual innocence, which is a completely different and much more significant question.
Yes, Representative DiLorenzo and then Representative Greason.
Thank you, Mr. Chair, and thank you for taking my question. Are there any advocacy groups in the prison that help convicted people with working on a claim sort of like this?
So that's a great question. At this point in time, although there is a group of folks that are within the prison that sort of help each other, there isn't an advocacy group that I'm aware of other than sort of the ACLU that can help people, and the ACLU doesn't do factual innocence, so we're the only ones. And we have no unique access to being able to help folks unless they apply to us, know about us, and reach out to us.
Yes, Representative Greason.
Thank you, Mr. Chair, and thank you for the information you've provided for us. The question I have is, in the language of this bill, it uses the word avers. What is the standard for averring something in a legal context? And is that a tight enough standard or high enough standard that, or would this potentially need to be modified?
So we don't think it needs to be modified. So under the statute as it stands, so we had originally drafted using a different language, but after we had spoken with the county attorneys, this was the language that was more comfortable, was avers. So the reason that it is because I think that's like legal language that the courts are more familiar with. The reason why we've included avers here is because this is what we're doing here is this is a petition standard, so it's not a hearing standard, right? So the hearing standard is in 526.1. The petition standard is in this statute, 526.4, the new bill. So all we're asking is that the pleadings have to allege these specific things. That's why avers is in there. It's not a standard of proof because we're not at a hearing stage. So at a hearing stage, a higher standard or must prove this beyond a reasonable doubt, this clear and convincing evidence, this preponderance of evidence doesn't apply at a pleading standard because we're only laying out the rules for a pleading at this point. And that's why we've used that here.
Other questions for this witness? Saying none, thank you very much.
Thank you.
Next, Paul Halverson, please.
Attorney Anderson.
Oh, all right, sure. So Attorney Halverson and Attorney Enders.
Attorney Enders did a deep dive into this, so I'll let him.
Thank you. Good morning. My name is Stephen Enders. I'm an assistant county attorney at the Merrimack County Attorney's Office. With me is Attorney Halverson, who's the Merrimack County Attorney. Both of us have been prosecutors for over 20 years. Certainly, we agree with the spirit of the bill and don't want to see innocent people incarcerated. And I think that goes without saying that all prosecutors I've ever spoken to, everyone at the AG's office, we all agree we don't want to see innocent people incarcerated. What strikes me about this is it's an amendment to RSA 526.4. And when you look at Chapter 526, it's the chapter that deals with new trials. One of the things about Chapter 526 is it hasn't been amended since 1842. And that's the entire chapter itself is in the same condition as it was in 1842. So being a curious person, I pulled the 1842 revised statutes, and this was originally under Title 22, which was titled Of Reviews and New Trials. And one thing that has changed in some of the language is the first part in 1842 did read, in all civil actions which judgment has been rendered in the court. So certainly, this only originally in 1842 dealt with civil cases. And that makes sense because even the language in, 526.4 talks about judgments. And we know that judgment is a civil thing. It's not part of the criminal context. And we certainly know it was civil in 1842 because the chapter before this in 1842 was chapter 190 that talked about all judgments shall be rendered in dollars and cents. So this is language from 1842 that doesn't necessarily fit into our modern context. One of the other issues how this doesn't fit into necessarily our modern context is that the circuit courts were established in New Hampshire, I believe, in 1963. So this statute only talks about petitioning in Superior Court. And there's case law that says this only applies to Superior Court, not necessarily Circuit Court decisions. So I initially have some concerns about amending an 1842 statute that deals with civil cases in Superior Court to allow motions for new trial in criminal cases. As Attorney Mousseau pointed out, there is another spot in New Hampshire statutes, RSA 651D, that talks about post-conviction DNA testing. That doesn't contain a statute of limitations. And it strikes me that if maybe there's a new scientific understanding that perhaps instead of amending 526.4, it may make sense to either expand the post-conviction DNA testing to include other scientific methods other than DNA, or write a completely new statute that talks about new scientific understandings. When I started doing a little bit of research on this, I found that Texas has what is sort of colloquially referred to as a junk science statute in the Texas Code of Criminal Procedure. It's section 11.073. And that makes it clear that if there's a new scientific understanding that can form the basis for a HABE, at least in Texas, and that may make sense to have a statute similar to that in New Hampshire. I certainly agree that I was at the table when we initially discussed the language here, as was Attorney Halverson, and we tried to come up with language that, again, limited this to criminal cases. Our concern with civil cases was at some point, I think in civil cases, you want a final judgment. I know we had talked about like a motion to quiet title on real estate, that if you could file a motion for a new trial forever after that, you could never necessarily have a quiet title in real estate. But what always sort of concerned me and didn't feel great about this proposed language is that while Attorney Mousseau is clear that this only changes the time frame, and I agree, changing the time frame is a good thing, it almost seems like this changes the process as well. And the reason I say that is because when I first read it, it struck me that this was changing the process, that if you could file a motion that averted a new scientific understanding, you'd essentially be entitled to a new trial. And I agree with Attorney Mousseau, that's not what this says. But I initially read it that way. And then when we sent copies of this to the Department of Justice, I know that there were some concerns from members at the AG's office that they thought this sort of changed the process as well. And I know Attorney Lehman, who's the Senate legal counsel, had that same concern, or at least I interpreted that to be the same concern. And we set up a second meeting, but we were a little, I think, too late to change anything. One of my suggestions would be if the legislature were to pass this bill and amend 526.4, what I would suggest is that to make it clear that we're only dealing with the statute of limitations and not the process, paragraph 1 starts out, a new trial shall not be granted unless the petition is filed within 3 years after the rendition of the judgment complained of or failure of the suit. And I would respectfully suggest that perhaps to make it clear that we're only dealing with the statute of limitations, that paragraph 1 be changed to begin, a motion for a new trial shall be filed within 3 years. So replace the language, a new trial shall not be granted unless the petition is with a motion for a new trial shall be filed within 3 years. And that language, a motion for a new trial, is sort of stolen from the rules of criminal procedure, specifically Rule 43, that talks about the time frame for filing motions to reconsider. But I think that would help make it clearer that this only deals with the time frame and not the process. I'm not sure if Attorney Halverson had anything to add, and I know I'd be happy to answer questions if anyone had any.
It all comes down to the statute of limitations issue. I agree with Attorney Endres with his recommended change on line 5 there. There was a question earlier, I believe, too, about using the word aver. I actually was uncomfortable with that word to begin with, but I looked at the colloquial definition of it, and I think it fits. So I have less concern about that. I think there are also 2 questions about the number of petitions that may be filed for a new trial and granting a new trial, how many would be granted. I think that question flows with what Attorney Endres pointed out concerning our initial reading and other people's readings of the language in paragraph on line 5 that Attorney Endres is suggesting to change to make it clear that this agrees or addresses only a statute of limitations issue. So should you wish to go forward with this, that would be my recommendation too, would be to change that language on line 5 as Attorney Endres mentioned. Other than that, I have nothing to add to Attorney Endres's comments and glad to take your questions.
Representative Smith.
Thank you, Mr. Chair. I found your historic research just fascinating, and I thank you for the time that you put into it. But now I'm looking at 2024, and I'm looking at existing law. I'm looking at existing practice in the last 80 years that has us established in practice interpretations. I look at number 1 and realize that, and there's a question, and realize that the only change in number 1 is to take the language 3 and turn it to numerical 3, period. And then number 2, which says this time limit shall not apply to a motion for a new trial, and goes on from there. So my question is, I understand that you said when you first read it, or when the Attorney General first read it, or perhaps when we first read it, we thought perhaps it might mean this. But on more careful reading, we see clearly what is meant, and therefore, with all due respect, why are there any legs left on your argument, since on further reading you realized what this meant?
I'm glad I can convince you that's what it means. And I hope that if I find myself in front of a judge with an opposing attorney who's saying, no, this clearly says if we aver newly discovered evidence, we get a trial, that I can convince that judge that that's not what it means either. And that's my concern, is that when you're dealing with the criminal justice system, you're dealing with people who are making judgment calls, and I'd be concerned that a judge may perhaps misread that.
I don't want to belabor, it's getting late, but I do want to ask you, acknowledging that even the members of the third branch of government are, some of them at least, have not been perfect. Of course, we know that some have been perfect, but others have not been perfect. Don't we assume that these are knowledgeable, trained people who are in a court proceeding which, under our law and our traditions, have people representing both sides? And those attorneys are responsible for making sure that the questions are raised and answered. It says very specifically, shall not apply, and then it goes on. So I don't think we can expect any legislation to require perfection. But isn't this specific language clearly stated, so much so that when you read it more carefully, you realized it?
I think it could be clearer. And I also think, and I mean, and that's why I suggest an amendment to change it from a new trial shall not be granted to a motion shall not be filed, because I think that does make it clearer. And unfortunately, I think mistakes can be made, and that's why we have a Supreme Court, and that's why we have appellate review. My concern is that when we're talking about new trials, you're also often talking about victims, and you're talking about people who have gone through trial and maybe had some what they believe to be closure in their life, and then they get a phone call from the prosecutor's office 8, 9, 10 years later saying, hey, this person who was convicted after a trial is now seeking a new trial. I think that can be potentially stressful, and I think it would be important to get it right to begin with.
Mr. Chair, I know we're not supposed to exchange in dialogue, and so I won't. And but please know that I would certainly have liked to respond to that.
Questions, Representative Manos.
Thank you,
And-
Mr. Chair, and thank you for taking my question. The House just passed a bill 1432 that sets criminal and civil penalties for the use of AI and deep fakes that injure people. And so I'm just, and that bill originated from this committee. And so I'm just struggling with the lack of civil relief, because theoretically somebody could be convicted for a criminal offense using AI, and then new scientific understanding could come forward that would say this person didn't create the AI and the deep fake, but it was somebody else. But still there would be civil liability. And so I'm struggling with that. So if you could help me, I'd appreciate that.
For me personally, again, I find myself in a situation similar to Attorney Mousseau in that I'm not a civil attorney. So I don't know that I can help you with that.
Same from my side.
Was there other questions over here? Did I see other? Yes, Representative Stapleton.
Thank you, Mr. Chair. Thank you for taking my question. Going back to just a previous discussion a moment ago, I'm going to ask the question, while closure and victims' concerns are immensely important, do they trump the focus needed on establishing innocence?
Absolutely not.
Without a doubt not. And I think, and in my conversations with other county attorneys, and I contacted, I believe, all of them on this issue, and every prosecutor otherwise that I talked to, local prosecutors, all agreed that the steps, if someone has an issue with the science and something about their actual innocence, it ought to be brought before a court. And frankly, I think Attorney Mosu and I and Attorney Anderson, every other attorney that I know, wouldn't disagree with that.
So peripheral considerations of closure and victims' concerns are not a consideration for evaluating new possible evidence that might point to innocence.
Not a valid claim.
Right. Yeah. Thank you.
All right, Representative Kassab.
No, I wanted to ask a question of the chair, if I may, but
No.
I can wait till after.
Okay, all right. Any other questions for these witnesses? Seeing none, thank you very much.
Thank you.
Is there anyone else who wishes to testify on Senate Bill 507? Seeing none, I'm going to close the hearing on Senate Bill. Sure. Yes, absolutely.
I wanted to ask if it's possible to have the committee researcher look into this a bit, because as I'm looking at the statute that the attorneys before us just pointed out regarding DNA testing, it is quite an extensive list of requirements that you have to meet to even be allowed to have a hearing and whatnot, and proving like why this DNA wasn't previously available versus this current bill before us is like 2 sentences versus this entire chapter. And so I'm curious, in these other states which do allow for broader amounts of times to have a rehearing, if their chapters are more descriptive on all of this burden that you have to prove. I'm concerned that the terminology and whatnot would just open up the floodgates for lots of potential petitions. And I wonder if we could kind of do a little bit of research to see what other states are doing.
Sure, we can have, I mean, we can definitely ask our committee researcher to look into other states. And I mean, I know you're right. I had a significant involvement in the DNA statute when I was still on the court, in a one case in particular. But yes, we can do that. All right. All right. So we have no other witnesses. So I'm going to close the hearing on Senate Bill 507. And I guess what I would like to raise now, before we get into our executive session on the other bills, is with regard to Senate Bill 185. I guess I would have to say I think I completely share the ranking member's concerns that I'm very suspicious that the report we get from the study committee in November is going to say we are at loggerheads and we haven't really advanced the ball very much. But maybe I'm just being overly negative, and and Senator Prentice may have a very good point that maybe the pressure has built that will cause people to come together. So my inclination is that despite sharing Representative Smith's reservations, we should pass 185. And so I would propose, since it's only a study committee, to exec it now if Senator Smith is agreeable to do that. Representative Smith is agreeable to do that.
I would consider it actually a demotion. I think it shows that the chair would just as soon be rid of me. But that's not true, because you have to raise money to run for the Senate, and I won't do that. I won't stand in the way unless I hear any objection from any of my Democratic colleagues. If you want to go ahead now.
And I guess I should say, I'm sort of thinking that from the questioning, I was sort of assuming that everybody was going to say, even though they had reservations, we might as well go ahead. If I'm reading that wrong, then maybe we should do something else.
I've got a question. I'm wondering if, and it stems from the question that I asked, is not only can we permit some of these patients to take up some temporary residence at a county nursing home, and can we do this through administrative rules and not the legislative process, where there could be a memoranda of agreement between the hospital and the county nursing home? If they're already, I believe I understood that there's already a private nursing home, a contract between a hospital and a private nursing home. If they can do that, why can't there be something between these hospitals and a county nursing home for a temporary residence until a permanent solution can be fixed? But that doesn't need to be legislative. At least I wouldn't think so. So could there not be something done through rules that would allow them to do that?
Right. I mean, I guess you may be entirely correct, but I mean, I think Senator Prentice, if she was here, would say, and that's something that the study committee could, include in their report. But anyway, Representative Alexander, then Representative Lanza, and then Representative Kutab.
Excuse me, I hate to be stuffy about this, but if we are going to be discussing this bill, then I think you have to open up an executive session on this bill.
Well, no, you know what? I guess what I'd say is this:
because the hearing was closed. So there either has to be a work session, which would have had to have been declared, or an executive session, which you could start with the agreement of the chair and the ranking member. But just the general conversation, we could have down in the lunchroom, but I don't think we could have here.
All right, so here's, I guess my question is this. I was thinking that everybody was sort of generally on the same page that we should just exec this and get it done. It sounds like I was wrong in that, and if that's the case, then I would say, my inclination would be, let's not exec this today, let's exec it some other time.
I think you might be on this, you might be on the right track, that we are all ready to exec. What I'm not sure you're on the right track with is what the motion is, and that's where the difference is.
I agree. I think we're all probably ready to move, but I would say I want to ITL it because I think people can just get together on their own. The number of people on that committee isn't a quorum.
Representative Perez.
I would like us to move to exec Senate Bill 185 today and see if we can come to a decision on that before we do any further discussion.
Representative Andrews.
Thank you, Mr. Chair. I am totally against this bill. It should be ITL, and I'm going to tell you why. As far as I'm concerned, the New Hampshire...
Wait a minute, hang on. So wait a minute, hang on. Based upon what I have heard, we are not execing this bill today. It's clear that there are disagreements because...
I think everybody agrees.
So let me just, fine, let's take a straw poll. So first, let me sort of propose it. What if the motion was ought to pass on this, who would vote ought to pass? Wait, just hang on. We're going to take a straw vote on this. We're going to take a straw vote. If we were to exec this and the motion was ought to pass, who would vote ought to pass? All right, and who would vote something other than ought to pass? Okay, so that is enough to say we're not going to exec this today. We need to have a more thorough discussion on it, and it sounds like, for example, myself and the ranking member would have a different view. So that in itself would say that we shouldn't go forward. All right.
A rare occurrence.
Point of order.
All right. Yes.
I did make a motion.
Well, but
You made a motion, but we're not in executive session. So the motion is out of order.
Oh, I got bad advice.
All right. So now I am going to open the executive session on the three bills that we had noticed for 11 o'clock, and I know we're behind. It's Senate Bill 314, Senate Bill 327, and Senate Bill 435. I see that we have in the audience, and I know they've been waiting for a significant period of time. So in the interest of not having them wait any longer, I'm going to take up 435 first. This is the unit trust bill. You all have an amendment which I sent to you last night, and it's now been circulated this morning. It's amendment 2024-1454. And so I would like to move that amendment and ask if there's a second. Seconded by Representative Wallace. And if I, just making a note here. If I could just speak to it briefly, I think.
So the first motion you're moving is ought to pass, correct?
I'm sorry, ought to pass. Yes, I ought to pass on this amendment. And I guess I would speak to it to say, I suspect that many of you, as you started to read this, your eyes glazed over because it's very technical. I think we got some very good testimony at the hearing about what the bill is intended to do, and what the amendments to basically to correct sort of language difficulties in the bill I don't really think that there's much in the way of, if anything, in the way of any substance in the amendment that changes the substance of the bill. As Senator D'Alessandro indicated in his testimony, and as the witnesses have indicated, this is an important bill, I think, for continuing to have New Hampshire move forward as a state that has very well-developed and modern trust law. And so I think it's important. And I guess that's really, and I think it's done right, so to speak, in here. And so that's really all I have to say. Anybody else have any comments on 435? Yes.
I have a question. You said just kind of technical changes, and as I declared last time when we discussed this bill, and as I repeat, I don't understand a blessed thing, and so I'm not pretending that I understand anything substantively, but when you say in line 14D, after a trust is converted to a unitrust, the provisions of 564C107 shall apply, and then everything's crossed out after that. So tell me what happened to C107.
107. That's
Well, this is changing Part D, right? That you're talking about line 16 to 29 on page 1.
right.
Yep.
Right.
And I see
So-
106F. I mean, anyway.
It looks like that's deleting like just out of that Part D, out of this list, this whole piece.
So you know what I think, and I'm going to ask Mr. Perlow if I'm wrong on this, but I think that the material that is crossed out in section starting on line 16 through 29 on page 1 are because that the C1107 governs that. Mr. Perlow, I know, I see you're in the back of the room. If I'm wrong on that, please, correct us.
And where
That
is
was part of the
C107?
initial.
That's on page 2, starting at line 18.
18. I see. Okay. That answers that question. Thank you.
And that was part of the initial bill. That didn't change in this amendment, these crosses.
Okay.
Are there other questions? All right, so then I guess on the amendment, can we, anybody object if we do that by a show of hands? All right, so all in favor of the motion to pass or adopt the amendment, please raise your hand. Any opposed? All right, so it's unanimous. All right, and then on the bill itself, I would move ought to pass as amended. Is there a second? All right, seconded by Representative Wallace. All right, and I would ask anybody have any other comments, questions, anything on the bill?
Mr. Chair?
Oh, yes, Representative DeLorenzo.
Hi, thank you, Mr. Chair. I feel like I don't know enough about this, even though I've read everything and I've been through it and trying to reason, what this is all about and what the liabilities might be for the state. And when I think of that way, I think about the FRM scandal from a few years ago where we ended up having the taxpayers foot the bill for the losses because of bad actors. And so that makes me a little bit skeptical. So I'm hesitating. Thank you.
Okay, all right. Other, Representative Smith, did you have a comment?
I do have a comment, Mr. Chair, and because I vote first when we get to my part of the roll, our part of the roll call, I want to explain that at the moment, I am leaning to oppose or to pass, having nothing to do with the merits, but having to do with the process. I have great respect for the private bar. I have great respect for how they help us understand what's happening out in the real world rather than in Alice in Wonderland where we live here. But I don't have confidence that I understand the implications enough to be responsibly voting in a way that might affect the financial security of people in the state. I make no pretense that I know what I'm doing, and I don't expect anyone to follow. And I might be the only one who would vote that way. I just don't feel comfortable without our having had a subcommittee, a work group, a side-by-side analysis, whatever. And so I want to say that so that no one thinks that by my voting any way that I would expect anyone else to follow. Thank you, Mr. Chair.
All right, anyone else? Representative Wallace.
Thank you, Mr. Chairman. If I might just make a couple of comments so people might understand this a little bit better. And again, this will be the Reader's Digest sweetened condensed version. As a trustee sitting on a whatever the type of trust it might be, you are bound by your fiduciary responsibilities and obligations to both the current income beneficiaries as well as the subsequent heirs of the grantors of a trust. This change in statute provides an opportunity so that the trustees can manage both fiduciary interests to the current income recipients of the trust income and future generations by adopting a hybrid investment strategy, which will ensure better and optimum performance for all heirs and all beneficiaries going forward and throughout time. And experts in the room, feel free to correct me if that was not quite accurate. We're getting a unanimous nods. Okay. So hopefully that might dispel some of your concerns.
So, I'm sorry, do other people have any comments? So here's my, I guess what my concern is this. If people are uncomfortable voting on this now, I don't want to in any way, we don't have to exec this today. And I'm perfectly willing to put it off. My only concern is this. I certainly don't profess to be an expert in this area of the law. And although we have other attorneys on the committee, I'm not sure that any of us are experts in this area of the law. I think we did receive testimony from people who are experts in this area. And I don't recall hearing anybody on the committee questioning them or suggesting that there was something more that they needed to hear or that we had some concerns about things. And so I guess what I'm concerned about is if we don't exec this today, our hearing is over. So unless we were going to have another hearing, we're presumably not going to hear any new witnesses. And so I'm sort of left with the idea that if we wait 2 weeks to exec this, we're going to be in exactly the same position we are in right now. Without any further information, unless, there's somebody on the committee that wants to become an expert in trust law between now and 2 weeks, and I can tell you that that's not going to be me. So that's why I guess I would suggest that it makes, and I would note, this has gone through the Senate. It's been gone through line by line, and I think with great care by Mr. Perlow and people who were working with him, who was one of our witnesses last time. When we got the first draft of an amendment back, I submitted it to him to said, make sure, can you please take a look at this and make sure that they've incorporated all the proposed changes. And he and his people that are working with him went through it line by line and got back to me with a very nice sort of summary of here are things that they missed. Here are the changes that should be made. That was submitted back to OLS for this current amendment. And when the current amendment came back, I went through it to make sure that all the changes that had been suggested were captured. So again, if people are uncomfortable in voting on the bill on the ought to pass as amended now, then we will not have a vote today. I don't want anybody to leave here thinking that there was some rush that we had to do this today. But I really am sort of left like what are we going to do if we don't do that? So can I just ask before we actually take the vote, can I just ask for sort of a show of hands of who would be willing to vote ought to pass as amended right now? Right. And who would rather not do that right now?
I'm not asking for a delay.
Okay.
I'm not asking for a delay.
Okay.
I'm just explaining my
Okay.
vote.
Your vote. All right. Okay. All right. So it appears that we have a fairly substantial majority that are willing to go forward. So I'm going to ask the clerk then to call the roll on my motion, seconded by Representative Wallace, to ought to pass as amended on Senate Bill 435.
Vice Chairman Wallace.
Yes.
Rep. Alexander.
Yes.
Rep. Andrews. Rep. Testerman.
Yes.
Rep. Stapleton.
Yes.
Rep. Tripp.
Yes.
Rep. Greason.
Yes.
Clerk Katab votes yes. Rep. Perez.
Yes.
Rep. Smith.
No.
Rep. Horrigan.
No.
Rep. DiLorenzo.
No.
Rep. Kenny.
Yes.
Rep. Carey.
Yes.
Rep. Jack.
Yes.
Rep. Lanza.
No.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Rep. Ming.
Yes.
Chairman Lynn.
Yes.
Motion passes 15-5.
Okay. Okay. All right. I will write the majority report. Will there be a minority report? Seeing none? Okay. All right.
Mr. Chair, I just request that the majority report be less legalese and something that non-lawyers can understand.
You
So
can count on it.
maybe like not a full page. Thank you.
Short and sweet. Absolutely.
No minority report?
No minority report. Right. All right. No minority. All right. Okay. All right. Next, I would turn to Senate Bill 314 relative to competency evaluations. Do I have a motion on that?
I'll move ought to pass.
All right. Representative Kutab moves ought to pass. Is there a second?
I second it.
All right, hang on. Representative Tripp. All right, Representative Kutab, would you wish to speak to your motion?
That's okay.
All right, anybody else wish to speak to it? The only other information I should give you, which is I did send a copy. I just sent an email with a copy of, or I'm not sure if I sent a copy of the bill, but I sent an email to the Attorney General's office asking them if, do you have any problem with this proposal, that kind of thing. And if you do, get back to me. And I haven't heard back from them, so I assume that they do not, which gives me comfort that, this isn't like way out in left field. So, Representative Smith.
Thank you. I acknowledge the problem that is the importance of the problem that is addressed here. And I acknowledge the substance of the testimony that we received. I am troubled by a reliance on electronic hearings, particularly involving, by definition, individuals who might not be able to function at the extremely high level that all of us sitting around this table can function. And that bothers me. And I would be interested in knowing how other people feel about that.
Representative Katat?
I was concerned about that as well, but then I remember seeing in the bill that it stated that you only had to do that if agreed. So the party could just waive and say, or the attorney could for them, could say that they didn't want to do that. Wasn't that
if I could, I hear what you're saying. There is no fiscal note, and so I'm wondering if there is a guarantee of legal counsel that is included in this, or is it possible that someone would be involved in I mean, it is, I guess it's criminal because it's prosecutor or defense counsel, but so that I believe there has to be counsel provided, but why isn't there a fiscal note then?
Well, you know what? I mean, I don't know for sure, but it may be that these proceedings are conducted already, and so it may be that this changes the procedures, but
not the
whether it will have no effect on cost, I'm not sure. I mean, but it may be not a substantial amount. Yes, Representative Stapleton.
I hate to dive in on this, but shall be guilty. It's kind of pejorative, and going to the next line, subject to the punishment. What about subject to due process?
I'm sorry.
I just have a problem with the word guilty in there. I know where it's coming from. It's a message that you could be subject to the RSA's pointed to in the first part, but a declaration of guilty in the law just doesn't seem appropriate.
I'm sorry. Can you tell me? I'm not sure where you are. Which part? What language are you referring to?
We're on 327, right?
3-4. No, we're on 314. We're on 314.
314. Oh, well, okay. Sorry. I'm in the wrong pew here.
All right. No problem. Any
Disregard, thank you.
Any other comments? Any other comments on 314? All right, then I'd ask the clerk to please call the roll.
Vice Chairman Wallace.
Yes.
Rep. Alexander.
Yes.
Rep. Andrews. Rep. Testerman.
Yes.
Rep. Stapleton.
Yes.
Rep. Tripp.
Yes.
Rep. Greason.
Yes.
Clerk Katab votes yes. Rep. Perez.
Yes.
Rep. Smith.
Yes.
Rep. Horrigan.
Yes.
Rep. DiLorenzo.
Yes. Yes.
Rep. Kenny.
Yes.
Rep. Carey.
Yes.
Rep. Jack.
Yes.
Rep Lanza,
Yes.
Rep Manos,
Yes.
Rep Tur,
Yes.
Rep Ming,
Yes.
Chairman Lin.
Yes.
Motion passes 19-1.
Can this go on consent? Anybody object to consent? All right, consent. And Representative Kutab, can I ask you to write the report?
Sure.
Then lastly, we're going to turn to Senate Bill 327, and the chair recognizes Representative Kinney.
Thank you, Mr. Chairman. I would move Amendment 1449.
Is there a second?
I'll second it.
All right, hang on. Move Kinney, second Perez. All right, Representative Kennedy, do you wish to speak to your amendment?
Yes, please. So it's a very simple amendment. In the original bill, it changes lines 18 through 23 based off Attorney Studidopoulos' testimony. He has been a sports official longer than I've been alive, so he has a lot of experience with this. Two things he felt missing in the bill that would be relevant. It's on the amendment, it's on line 5, stalking and criminal mischief. So this amendment just simply adds that language in.
All right, any, it does make sense to me. Any other comments on this? All right, then, so I would propose to just have a show of hands on the amendment. If all those in favor of the amendment, please raise your hand. Any opposed? All right, so that passes. Whoop.
Stapleton.
Probably, as I previously stated, under the wrong bill.
Okay.
And this is 1449H.
Shall be guilty of the offense. All right, so I'm sorry. So you were opposed, voted no. Then all right. So all right. So then we have I guess 19-1. Is that correct? Or Representative Andrews, were you all right with the amendment? Oh, she was. Okay. All right. All right. So 19-1. OTP. And Representative, Chair recognizes Representative Kinney, who is desirous of writing the report on this matter.
We have to move OTP.
Right, do you have a, oh, no, I understand. Do you have a motion?
I'll move OTPA.
All right, is there a second? Seconded by Representative Perez. All right, any further discussion on the bill? All right, then I would ask the clerk to call the roll.
Vice Chairman Wallace.
Yes.
Rep Alexander.
Yes.
Rep Andrews. Rep Testerman.
Yes.
Rep Stapleton.
Yes.
Rep Tripp.
Yes.
Rep Greason.
Yes.
Clerk Katab votes yes. Rep Perez. Rep Smith. Rep Horrigan.
Yes.
Rep DiLorenzo.
Yes.
Rep Kenny.
Yes.
Rep Carey.
Yes.
Rep Jack.
Yes.
Rep Lanza.
Yes.
Rep Manos.
Yes.
Rep Tur.
Yes.
Rep Ming.
Yes.
Chairman Lin.
Yes.
Motion passes 20-0.
Mr. Chair?
Yeah. Yes.
I'm wondering if at some point we might actually be able to see our way clear to have a bill that protects members of the legislature from egregious comments made by or threats made by our colleagues. Wouldn't that be a good idea? Thank you.
Consent. You know, can this, anyone have object to this going on consent? None. All right, so it'll be on consent. And Representative Kinney, those who are writing reports, I have this little note.
Yes.
The speaker would like reports in today if possible.
On the bottom in fine print it says.
So can you both get me, and I will get my very non-technical short report in by the end of the day today on 4:35. So you know what? Just before we recess, just to let everybody know, we only have one other bill that we've received from the Senate that we haven't had a hearing on. I would propose, and we need to exec the two bills that we did have hearings on today. I would propose that we not have a session next Wednesday for just that. That, you know, yeah, we might, well, I think we're probably gonna get at least maybe one and maybe two other bills. For some reason, we're pretty light, on Senate bills. So I think we'll have plenty of time to, you know, hear those bills and exec it, and,
So the earliest we would plan for us to meet again is the 24th.
the earliest would be 2 weeks from today. 2 weeks from today, okay?
Just a note, I'll be away that week. That's April vacation week.
Ah, okay, all right. All right, so, we'll miss you, but, you know, you can, send us a text from. Well, you know, I guess what I would say is this, we certainly won't have a meeting before the 24th, but just once I know we have all the Senate bills that we're going to get, if it looks like it's not going to be any heavy lifting at all, maybe we can put it off until the week after that even. I mean, that's, you know, I don't have any problem with that if we can do it. As long, yeah, but,
We have,
Substitutes?
oh yeah, for sure. Thank you very much for being here. We really appreciate it. And for your questions too. I mean, that was excellent questions. Really appreciate it. All right. Any other business? I guess we're adjourned. Thank you, everyone.